Hi, very good morning. This is a Supreme Court judgment in NBCC India Limited versus State of West Bengal. Issue before the Supreme Court was, can an MSME, micro, small and medium enterprises, make a reference to the Facilitation Council for resolution of disputes if it is not registered under MSME before the execution of the contract with the buyer? So question is clear. I am not registered at the time of making a reference to the facilitation council. I am a small, medium and small enterprise, micro and small enterprise. So can I refer the disputes to the facilitation council even though I am not registered? That is the question before the Supreme Court. Facts, I am not going to narrate the entire facts. Simply put, an enterprise referred a matter for resolution of dispute before the Facilitation Council. NBCC filed a writ petition before the High Court and raised two objections. One is, enterprise was not registered before the execution of the contracts, and hence Facilitation Council does not have jurisdiction. The second ground was, subject matter of the contract relates to execution of works contract, which falls outside the scope and ambit of the Act. A single judge bench dismissed the writ petition on the ground, whatever issues you are raising, you please go and raise before the arbitral tribunal. That is what the single bench said. They filed an appeal before the division bench. Division bench also dismissed it. Division bench said works contract is an indivisible works contract, and the MSME being a special legislation, it overrides all the other statutes. So they also dismissed it. This was challenged. The judgment of the division bench was challenged before the Supreme Court. A very good judgment by Supreme Court. Sorry, I am, even though I am a small fellow, I need to appreciate it. It was written excellently. Supreme Court took into account the decision of Shanti conductors, wherein the Supreme Court held that the liability of the buyer for payment under the Interest on Delayed Payments to Small Scale and Ancillary Industrial Undertakings Act 1993. This act was repealed, which was subsequently followed by the MSME Act under the previous act. The Supreme Court said that liability of the buyer arises even if the agreement of sale is prior to the act, but supplies were made after the act. So agreement was prior to the act, supply was after the act. Supreme Court said liability of the buyer is there. Supreme Court now in the present case, the Supreme Court considered interpretation of statutory remedies by a constitutional court and held that an effective judicial remedy under a constitutional scheme must be 1. Accessible, 2. Affordable, 3. Expeditious, and 4. Cohesive. All these 4 must be there for a judicial remedy. The rights and liabilities under the MSME Act are based on the incidence of supply made by the micro and small enterprises, which was there already in the previous act, repealed act. The court then considered whether registration under MSME Act is necessary for referring the disputes to the Facilitation Council. In this regard, the contention of the NBCC, the appellant, was supplier definition will not include an enterprise which was not registered under the MSME Act. So that was the submission, main submission before the Supreme Court. Court considered the meaning of the word supplier under the definition. Then section 18 of MSME Act uses the words any party to the dispute, within quote, any party to the dispute, and not the word supplier. Section 18, which is the section for referring the disputes to Facilitation Council, uses the word any party to the dispute and not the word supplier. Supreme Court applied the principle of golden rule of interpretation that the words of a statute have to be read and understood in their natural, ordinary, and popular sense. The choice of words, any party to the dispute, it was deliberate by the legislature and was intended to achieve the purpose of the act. Supreme Court said the purpose of mention of section 17 in section 18 is only to provide reference but not to confine the remedy to a registered enterprise. Supreme Court held that remedy under section 18 must be seen as a necessary step, unrestricted and open-ended, to enable any party, again within court, to a dispute to access the remedy. So Supreme Court clearly held on a consideration of the definition of supplier, section 17, section 18, that an MSME need not be registered for referring disputes to the, especially micro and small industries, need not be registered for referring the dispute to the Facilitation Council. On perusing the definition of supplier, Supreme Court said that it is relatable only to micro and small enterprise. This is very important. Otherwise, you may misunderstand the judgment. On perusing the definition of supplier, Supreme Court said that it is relatable only to micro and small enterprises and not to medium enterprises. So, if you are a medium enterprises, you must register involved in the production of goods. As per section 8, registration was not mandatory but was only optional for small and micro industries, but was compulsory for medium enterprises engaged in production of goods. That is why I said you have to note this very clearly. So the registration is not compulsory for micro and small enterprises, but was compulsory for medium enterprises engaged in production of goods. The court said that registration under MSME offers very little by way of tangible benefits to the micro and small industries. The court concluded that at no point of time registration of MSME was ever considered to be a precondition for availing dispute resolution remedy under section 18. Then the Supreme Court said the formation of micro and small scale industries is based on their investment. They subsist even without any formal recognition, consent or registration. Supreme Court held that an application under section 18 by a micro or small enterprise to the Facilitation Council cannot be rejected on the ground that enterprise was not registered under MSME. It rejected the submission that Facilitation Council cannot entertain an application by an enterprise which was not registered. So clear decision has been given. If it is a micro or small industry, if there are disputes between the parties, between the supplier and the buyer, then the Facilitation Council or anybody cannot object by saying that no, you are not registered under the MSME Act, hence we cannot entertain the dispute. So clear decision has been given. But Supreme Court proceeded further. The Supreme Court, the cases relied on by the NBCC was considered by the Supreme Court. And all the cases were distinguished, in fact, very well distinguished. Again, I'm a small fellow, I cannot say on that, but beautifully written, this judgment. It said an institution like Supreme Court, an institution that is the Supreme Court, performs two functions. This is very, please note this, very beautifully written. It performs two functions. One is decision making and the other is precedent making. Substantial portion of Supreme Court judgments are only for decision making. The court said every judgment or order passed by Supreme Court is not a binding precedent under Article 141. But the court also appreciated, Supreme Court also appreciated the difficulties of high courts and subordinate courts in determining whether a judgment is in the process of decision making or precedent making. Particularly when Supreme Court judgments say even a obiter of Supreme Court passing remark of a Supreme Court is a binding precedent for high courts and all the other courts. The Supreme Court opined that Supreme Court, generally all the other courts, when they are deciding, they must be cautious while deciding the cases and state whether the decision is for resolving the dispute between the parties only, that is only decision making, or meant to be a law under Article 141, that is precedent making. Then the court further said, referred the matter to larger bench on the following ground. The court said that on interpretation of the Act, MSME Act, a clear decision has been taken in this case. That is, they said you need not be registered under the MSME Act for making a reference of dispute to the Facilitation Council. That is, a clear decision has been made. But for the purpose of clarity and certainty, arising out of decisions of Silpi Industries, Mahakali Food, Vaishno Enterprises, and Nitesh Estates, wherein some remarks have been made. So the court said, we are referring the matter to a larger bench for the purpose of clarity and certainty. That is what the court said and referred the matter to larger bench. This is the judgment of Supreme Court. Thank you very much. Have a great and wonderful day. Bye.